Thank you for staying with us. You're still watching Newsday here on Arise News. The 2023 governorship election in Nigeria took place in 28 states nationwide, and the Independent National Electoral Commission had since announced winners in all the states. Soon after the results were announced, the battle shifted to the Governorship Election Petitions Tribunal across the country as parties dissatisfied with the results headed for the courts. Again, dissatisfied about how the tribunals ruled on cases brought before them, the aggrieved parties again headed for the appeal court. With mixed reactions trailing the outcome of all the cases brought to the tribunal and appeal court so far, we are now being joined by a lawyer and public affairs analyst, Okechukwu Oritsakwe, to highlight the latest court rulings in some states, especially in Imo and Plateau states, where judgments have been delivered so far. Good afternoon and welcome to Arise News.
Thank you very much, Shaitan and Nee. It's my pleasure to be here.
All right, then it's great to have you on Newsday. Let's get straight into it. Now, we've been seeing, there's been this funny thing that a lot of people say that our elections don't stop at INEC. It actually ends in the courts and through these different appellates of the court. Now, seeing all of these judgments coming in, what's your response to that? How would you properly analyze that? And do you think that this in itself is setting some kind of precedence where we know that regardless of what happens during the election cycle, it's still going to end up in the courtroom?
Well, of course, as long as we don't get things right, elections will continue to go to the courts and the courts will continue to decide like they have been deciding. Before elections are held, INEC usually releases their guidelines and make people to understand that they are going to abide by those guidelines. So when they get to the field, most times, they jettison the guidelines and do whatever they want. And when they get to court, the courts will pat them at the back and say, oh, INEC has the right and has the power to depart from their guidelines. So that is why politicians will continue to encourage INEC to declare them as winners so that the other party can go to court. Now, look at what happened in Plateau State. Let me start my discourse from Plateau State. That state has been thrown into political quandary. And in my view, that was clearly avoidable because this issue of nomination of candidates is something that has been settled a long time ago. If you did a combined reading of sections 29 and 84 of the Electoral Act, and also read section 285 of the Constitution, you will come to the reasonable conclusion that an election tribunal does not have jurisdiction to begin to question whether a person was validly nominated by their party. So now, the Court of Appeal has sacked 16 members of the Plateau State House of Assembly that were voted on the people's mandate. And their reason was largely that there was no structure that could produce valid candidates. But the Supreme Court now has affirmed the election of their governor from the same political party and the same structure that the Court of Appeal said they did not have. And honestly, it baffles every reasonable mind to see this kind of judgments or to hear about this kind of judgments because this is a settled thing. In the early period of 2023, the Supreme Court decided in Oni and Oyebanji an appeal from the election, the governorship election in Ekiti State. The Supreme Court laid this matter to rest, that anything about nomination is a pre-election matter and the tribunal does not have jurisdiction. In the just recently concluded P2B and Alhaji Atiku's cases against President Bola Tinubu, the Presidential Election Court, which is actually the Court of Appeal, said so, and the Supreme Court affirmed it. So for any judge to be claiming that they do not know the answer to give when they are presented with such question, then that judge is, I mean, with due respect to them, is either not reading or following up with the current trends or has some ulterior motive to serve. Now let us move to Imo State, the headquarters of judicial miracles from time immemorial. You know, the PDP in that state had a very problematic primary election. And there are candidates that went on to contest the election and were declared by INEC, had their elections challenged in the tribunal. The tribunal in Imo State had about 4 panels. 3 out of the 4 were dismissing that argument on nomination. But one particular panel stood out, the panel led by Justice Antonia Akpovi. He continued to insist that he had jurisdiction to entertain questions on nomination, despite the fact that few days before that panel gave those judgments, the Presidential Election Court had already said, in the case of Peter Obi and Alhaji Atiku Abubakar against Bola Tinubu, that election tribunals don't have jurisdiction. They disregarded it. So it begins to raise the question of where we are headed, as the Nigerian judiciary. And those cases went on to appeal at the Court of Appeal level as well. And today, I can tell you that there are people from that party, that PDP in Imo State, retaining their seats, while some people have been sacked. The same primaries, the same facts, the same judicial process, different results. There is a panel that also stood out at the Court of Appeal, the panel that was constituted by E.O. Williams Dawodu as the presiding justice, and Justice Mohammed Sirajo and Justice Abdulaziz Waziri, and PDP, held that anything about nomination is not within the jurisdictional purview of the election tribunal. He read the leading judgment in that case. Justice Waziri was on the panel that reviewed the case in Labour Party against Ndudi Elumelu from Delta State. Although he didn't read the leading judgment in that case, but in his concurring opinion, he said nomination is something that is a pre-election matter, and the tribunal would not have jurisdiction to entertain it. But these two justices met on a panel reviewing a case from Imo and did a direct 360 of what they said in those two previous cases. So all these things boil down to the same question we have been asking. What exactly are these judges after? And when people on the streets begin to cast aspersions on the integrity of judges, alleging that they take bribes or that they are corrupt, we members of the legal profession now seem to have no basis anymore to begin to defend them, because when you read some of these judgments, you begin to wonder if there was some smoke behind the screen. So we have to really beef up the integrity of our electoral process, because the courts are no longer doing as much justice as they're supposed to be doing. There is nothing that confuses in the case of a person's nomination and in the general elections of how people who have been nominated by their political parties should have been nominated. It's no longer a question that does not have an answer, right? So the Constitution says you should be nominated by your political party, and that requirement is satisfied as soon as the party just submits your name to INEC. The court does not have jurisdiction to begin to say, oh, how did you get nominated? No, the Electoral Act has already dealt with that. You can only challenge primary election if you participated in that primary, and if you brought the action within 14 days from the conclusion of the primary, and that action must be instituted at the Federal High Court. Anything more than that is a wrong approach. So this
Very
is
good. Okechukwu, if I may come in, you've elaborated, regarding all of this gale of court cases, as it were. But in hindsight, what will be the relevance of the lower courts in terms of the impact all of this Supreme Court verdicts is having on them? And of course, we're still going to delve into the Edo primaries 2024. But I'd like your thoughts on that. What would be the relevance of the lower courts, whether it's the petition tribunal or the appeal court itself, regarding the overall verdicts of Supreme Courts as we've seen in the past few days?
Well, in law, there is what we call the doctrine of stare decisis. Some people also call it the doctrine of binding precedent. And what it simply means is that in the hierarchy of courts, the decision of superior courts are binding on the decision of lower courts. And in the Nigerian situation, the decision of the Supreme Court, being the apex court in the land, is binding on all other courts under the hierarchy of courts. So And my understanding is that if a lower court fails to follow the decision of the Supreme Court, it can be rightly termed that they are guilty of judicial insubordination. So that is my answer to your question. A lower court tribunal does not even have the jurisdiction to depart from the decision of the Supreme Court. It is binding on them, and they must make reference to it in relevant facts that appear before them on the same issue.
All right then, but I just wanted to touch on the fact that we did see a lot of pre-election matters. These were unique commonalities and aspects in a lot of these gubernatorial, appeals that went to the three layers of the court or the court system. So in this particular situation, you speaking on it and saying that those are things that should not have necessarily been looked into. How do we avoid that kind of repetition from next time, where pre-election matters are not just are taken care of even before the election happens and not just discarded when it's time for the judgments to be made?
Well, the answer still lies in the judiciary. There has to be a judicial consistency in the way decisions are reached. The Electoral Act has already made provisions on how to challenge primaries. And if you look at those provisions, you could rightly see that the legislature just wants a situation where issues of primaries and all grievances arising from them should be concluded before the elections. So that is why the tribunal does not have jurisdiction to start going back to primaries when general elections are over. So if the courts can maintain a consistent approach in this regard, we would not have people coming to courts and doing this thing. And now the matter is getting out of hand because there are conflicting decisions on the subjects right now as we speak, especially at the Court of Appeal level. So if the court is going to maintain their integrity and maintain the integrity of their decisions and continue to discourage people from doing this, then we will not have a problem on this issue going further.
Indeed, I would have loved us to take other issues, but that's as much as we can take. Okechukwu Oritsakwe, lawyer and public affairs analyst, many thanks for your thoughts on those issues. Good to have you with us.